to authenticate as a witness, because frankly, we don't assume or take any guess what Ms. McCabe will say, where shortly after Mr. Kearney was released from jail, from what Your Honor just spoke about, where Ms. McCabe recruited Ms. Gaetani and orchestrated surveilling him from various police stations and to other locations, joking about going on a stakeout. In other words, conduct not consistent with her being intimidated. Those actions will also
the intimidation doesn't have to last forever. The intimidation, we're only trying one slice in time. That's the bedrock of any criminal defendant, right? But not trying his entire life, we're trying that moment.
But these are questions that have to be posed to Ms. McCabe, and she'll have and should be forced to answer them and explain them.
I don't necessarily disagree with that.
Okay, so the point is, we don't know what Ms. McCabe will say. We know based upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
Which seems to move with time from poll to poll, correct?
I'm not sure what you mean.
Well, it seems like her allegiances have changed as this case has developed.
She is, without question, a unique witness, which raises another interesting point, which could lead to the possible conflict with Mr. Cosgrove. She is a former prosecution witness. There's no question. She testified in grand jury. She testified at a trial called and vouched for by Mr. Cosgrove.
Quite enthusiastically, as I understand.
I believe so, Judge. No question. And at that point, they had no problem with Ms. Gaetani. But at this point, she's now sued Mr. Cosgrove. She has sued Tully. She has threatened to sue or sent a demand letter to the DA's office. And when that happened, Mr. Cosgrove said, I have a conflict with her because he has a personal interest in seeing her discredited. And I'm going back to what I first started with, Your Honor. The issue is not because she's an alleged victim. She's a potential witness in this case, and the prosecutor has a personal interest in seeing her discredited. And the critical part comes in the argument to the jury at the end of the trial. When McCabe has testified, it's in Mr. Cosgrove's personal interest that she be credited, Gaetani not be credited. When Tully testifies, it's the same exercise. He's a co-defendant of his.
What's Tully going to testify to?
Is Tully going to testify? We're not calling Tully.
Mr. Cosgrove, what's Tully going to testify to? Is he even a witness?
I haven't made a determination as to whether I'm going to call Lieutenant Tully or whether I'll need to call Lieutenant Tully. It seems to me that the videos, which Mr. Kearney has himself made public, documenting
vouching for the credibility, not in an illegal sense, but advocating for the jury to adopt Jen McCabe and discredit Lindsay Gaetani. The jury should not be ignorant to the fact that this guy's getting sued and wants her to be discredited. That is not the kind of thing that the public can have confidence in when they find out that the prosecutor who is judging everyone's credibility is discrediting her, crediting another, and it's tantamount to him giving unsworn testimony.
This goes back to the issue of relevance that we talked about before, and this is where I'm a little bit hung up. What McCabe does 6, 8, 10 months after the allegations here, because the allegations with regard to McCabe, as I can tell, they occur on 6/6, 9/20, and 7/22. Those are the 3 dates where she's alleged to have been intimidated. So none of these matters involving Gaetani develop until perhaps December, right?
Gaetani's, some of her testimony, though, Judge, will corroborate other evidence we have of Jen McCabe's pattern of surveilling Mr. Kearney.
But when
before he was indicted.
But when?
In 2023, July of 2023. We have documented evidence of her, the intimidated and emotionally harmed witness, contacting Mr. Kearney on social media and alluding to the fact, I know where you are, which is exactly what we're talking about with Gaetani.
That's a fair point to cross-examine her on, no doubt.
Don't know what she's going to say. From our perspective, having seen some of her other testimony and other proceedings, we don't just assume that she's going to be forthright. And we have a right. She's the star witness of this case.
I may need to know a little bit more about that. In terms of, if you want to file something and pound it to me, that's fine.
The final point I'll make, to Your Honor, before you have any other questions, is it's important that we're raising this now. This is well before trial. The prosecution is clearly on notice. I don't know where this may lead to, what else could be discovered. You know, this is a unique case, as you've noted, and evidence is discovered in all kinds of odd ways, believe me, with how these cases proceed and who shares what and those kinds of things. It's critical for us to make this record now, alert the court respectfully.
I have no issue with you making a record.
Because if it comes up later after a jury is impaneled, there is a risk of a mistrial, and that will not be our fault. And we think at that point,
listen, Mr. Bitter, I have no issue with you bringing the motion. You're supposed to. You need to advocate for your client in any way you think is appropriate. I'm just trying to flesh it out here, so I understand exactly what the issues are. I'm struggling with the relevance issues. You may have to give me more information on that, so I understand it a little bit better. Because the way I read things, they're much later in time. Now, if you've got something that's more contemporaneous to the alleged intimidation, I think that's very, very relevant, and would have to sort of play out how that would come in and what the form of that evidence. So we'll come back to that at some point when you're ready to talk to me about that. But talk to me about this. Your motion had 3 parts. Your affidavit had 3 parts, and one was the 2024. That's moot because it's already been done. The second was this issue. The third was this idea that I could preclude the executive branch from investigating things in 2025. Can you give me some authority which says I have the ability to do that?
It's a unique situation, Your Honor. I'm not going to sit here and tell you that there is a case law roadmap to what's happening, but what's important to recognize here, you know, you've been asking us these questions about how is Gaetani relevant. She is extraordinarily relevant to what we're calling the 2025 investigation, which results in the search warrants for the phones of Karen Reed.
Which is still pending with Judge Krupp.
Right.
Let me play that out 2 ways. What if Judge Krupp says he can have access to the phones? Then we're going to have a much longer issue, correct? Is that going to come into this case?
Well, they're telling us that 2 people are under investigation. I mean, it's hard for us to know, right? I mean, they're attempting allegedly to indict Mr. Kearney and Karen Reed for actions in which they already tried to indict and a grand jury said no. And now 2 years later, with phones that have been gathering dust, we need to look in these phones and, you know, God knows what we'll find. But the point is, the search warrants in that case are critical and certainly could relate to evidence used against Mr. Kearney. There are two informants in that search warrant. One of them is Lindsay Gaetani. And the affiant of that warrant is Detective Tully. And there are about 10 paragraphs, and I'm paraphrasing, I don't know the exact number.
I read the warrants.
Relying on her, and it is loaded with information which she provided them. And we're back to the personal interest of Mr. Cosgrove. So that really was meant to just inform the court that this is a living, breathing issue.
I will agree with you, it's a living, breathing issue. It's just not a living, breathing issue over which I have authority.
Fair enough.
When that comes to me, if it comes to me, I don't know if my special assignment encompasses that. We'll see. But if it comes to me, then we'll deal with that issue. I can find nothing which gives me the authority to restrict that activity. Judge Krupp has the authority on the search warrants, and he'll make a decision in due time. But I find nothing which gives me the authority to restrict prospectively an investigation that's being done by the executive branch.
Judge, just before I sit down, and unless the court has any other questions, I just want to correct one last thing. Your Honor had mentioned about a lawsuit being settled. That is not the lawsuit involving Mr. Cosgrove. There's no...
Sure it is. I looked at the docket this morning.
Not with him. That's with other parties to the litigation, is my understanding.
Okay. Well, let me play this out for you. It's, as I said, I have some familiarity with this immunity issue since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again, an accusation is one thing, but it would seem like there's a little bit more. You'd have to have some substance to it to actually disqualify him. But I'll keep an open mind on it. Anything more?
Anything else?
No, I read all your stuff.
Thank you.
Anything more?
No, sir.
Mr. Braley, anything?
No, Judge, thank you.
Okay. Mr. Kearney, Mr. Cosgrove, if not, if you're conflicted out in one case, why aren't you conflicted out on the other? That's the real big question here.
Well, I don't think the two necessarily follow, Your Honor. Obviously, before I filed my motion seeking to withdraw in the other case, I would have been a poor attorney indeed if I didn't think about whether it also required me to withdraw in this case. And the motion to withdraw was, at least I attempted to phrase it quite carefully, to say that I had a conflict because Ms. Gaetani was the alleged victim in that case. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts. But nevertheless, it was essentially an argument that I would be making in that case, that Mr. Kearney committed crimes against Ms. Gaetani. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Gaetani's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if it came to trial?
Well, that's a very interesting point, Your Honor. And there's a couple of problems with it. One problem is the practical matter. I don't see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt the defense theory that everything is relevant to every issue, but I don't see how indicating that Ms. Kearney was not credible in making statements about the investigation of Mr. Kearney here would have any relevance to an accusation that I breached some sort of duty to her by turning over a police report, which is the contention. Also, Your Honor, assuming that this even survives a motion to dismiss, and I'm talking now about the Middlesex case, I don't think there's any factual dispute.
Worcester case, there's nothing in Middlesex, right?
I'm sorry, Worcester, yes,
Okay.
thank you,
All right.
I appreciate the correction. I don't think there's any factual dispute as to what happened. In my capacity as a prosecutor, I provided Mr. Bradel with the police report in question as discovery. It made its way by whatever means from Mr. Bradel to Mr. Kearney, who then publicized details of it and turned it over to a friend, an associate, whatever you want to call him, who actually put the whole report, as I understand it, on the internet and began pillaring Ms. Kearney over her credibility. I don't dispute that I turned that report over as a matter of discovery. If this case ever develops in Middlesex and comes to fruition, I couldn't possibly dispute that. That's the absolute factual truth. From that point on, it becomes a pure question of law as to whether I breached some sort of duty under the statute to Ms. Kearney under the mistaken belief that I had a Rule 14 obligation to turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias. Maybe I made a mistake. Maybe I was wrong legally. But that's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter...
How do we avoid the circumstance? But she's called to the stand, and there's some relevant testimony that she can offer. You wouldn't call her, but the defense calls her. And you're in the midst of cross-examining her, and she says, well, this is why I sued you. What do we do with that?
I'm not sure what you do with it, Your Honor. Maybe we deal with that with the motion in limine to preclude her from mentioning the Middlesex suit.
Doesn't sound like a terribly controllable witness.
Well, that's why we have skillful Superior Court judges, Your Honor, if I could
If you can find one, that's
be a little obviously self-serving in my comment. I'm sure Your Honor, both in his prior career, as I have in mine, and in your present position, has dealt with witnesses that are difficult to control.
What about the possibility of someone else coming in? Is that something that's realistic or not realistic?
I didn't quite hear you. Something else?
What about the possibility of bringing someone in to deal with Ms. Gaetano if indeed she's a witness?
Could be done.
Well, it would solve a lot of issues. Mr. Bedrow? I mean, you're not contending that the case goes away completely. You're contending that he can't deal with Gaetano.
Unless, Your Honor, I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani, but if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard-pressed to figure out why the issue of the lawsuit would come out.
Could. Again, I don't know.
But that is my job to control what comes out. But so
Yes.
Legally, let's think about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think we all agree.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure it out. I guess the first question is, why are we having this conversation, and why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we're having this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove...
I think he's not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. So it would appear to me what you're saying to me is, if there was a replacement for that issue, that would resolve this problem.
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility of Ms. Gaetani.
You'd agree with me that does happen in trials, not with some frequency, but it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a statement of a defendant.
Sure.
They have to be a witness, I mean, these kinds of things can happen all the time.
We find ways around them.
But we're also, to be clear, we're dealing with a very rare situation where the witness is a former prosecution witness accusing the prosecutor who she testified for previously of misconduct. Now, if the prosecution and the court approves of that process, wants to have that laid bare, then I suppose it could. But the other problem,
just on this issue, we're not going to hijack the rest of the argument.
Okay,
just on the issue of replacement.
I had a brief response.
Yeah, he's not done. You only get to respond when he's done.
Yes.
Mr. Cosgrove.
Well, just on that point, I have yet to hear how any comment that I might make on the credibility of Ms. Gaetani's testimony in the case before the court would even come in or be relevant in the Middlesex case or assist me in any way. Am I going to go over to Middlesex Superior Court and, frankly, I find it hard to believe that I or whoever would be representing me would be brazen enough to say to the judge, well, I want to talk about all the ways in which my client, Mr. Cosgrove, impeached Ms. Gaetani in a case that has nothing whatsoever to do with the case before the court. There's just not going to be any bleed through whatsoever, it seems to me. We don't even have, frankly, Ms. Gaetani's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that either the Commonwealth or the defense is going to call her in this case. Mr. Counsel has carefully said we may call her for the defense. This may be a contingency that doesn't even arise, but that's sort of a side point. Let me just take a couple of points. I was going to ask Your Honor to take judicial notice of the pleadings in the Middlesex case and the docket. It appears you've effectively done that, but let me make an oral motion on the record.
Any objection, Counsel?
No. Purpose.
Okay. Agreement. I'll take those as judicial notice as to the Worcester Superior Court case.
And one of the interesting, unique things about this alleged conflict of interest, which is a little different from the typical conflict of interest case, at least I haven't found anything precisely on point, and I don't think the defense has either, but maybe they'll prove me wrong in a moment, is the whole operation by which this alleged conflict has come about and the Middlesex case has come about. What is it that enables Ms. Gaetani to make the claim that she's seeking to make against me in the Middlesex case? It's that defendant took the report I gave him as discovery, or I gave his counsel as discovery in the other case, publicized it, and then created a harm that Ms. Kearney alleges accrued to her from that publication. In other words, if we're applying but-for causation, to sound like a tort lawyer for a minute, if we take Mr. Kearney's actions out of the whole proceeding, there's no harm whatsoever to Ms. Kearney with my, as I see it, fulfilling my Rule 14 obligation. So Your Honor has the unusual situation here of a defendant who has been but for cause of the alleged conflict, seeking to profit from that conflict by removing the prosecutor of his case, which I think is worth some consideration by the court. What I would like to do now, Your Honor, since the defendant has had the opportunity for a reply brief, which frankly doesn't particularly go to these motions, particularly, but more to the point, the defendant's reply in support of the motion to disqualify Robert Cosgrove. I'd like to examine that in some detail and take the opportunity to reply to some of his.
Well, it really hasn't become an issue here. That involves another party whose case has been dismissed. The case regarding the defendant and that witness is gone. That's dismissed. So I don't really know if that's all that relevant to any. Mr. Beddoe didn't even raise it.
For purposes of this, Your Honor, the briefs are what they are. We submitted them. I just raised the issues I thought would be helpful for the court today.
Yeah, I didn't find that anything with regard to that particular trooper terribly compelling because I don't understand how he would be part of this case. Fair to say?
You're talking about which trooper?
The trooper whose case was dismissed, Bouchard.
I'm not talking about the, I'm sorry for interrupting, Your Honor. I'm not talking about the motion that they filed with respect to discovery for Mr. Proctor.
Oh, I'm not dealing with discovery right now. Yeah.
I'm talking about the motion that's captioned, Sir reply in support of motion to disqualify Robert Cosgrove.
Paper 127 you're talking about.
I don't know the number, to be honest with you, but
this one here?
yes,
Yep,
exactly.
that's 127.
Okay.
Okay, go on, I'll hear you.
All right. So, the defense begins by complaining that my response envisions my conflict in a vacuum, and that it ignores the whole context, which is basically a preface, Your Honor, for talking about everything else that the defense is unhappy with about the case, except issues that are relevant to whether or not I should be disqualified. There is, on page 1 of that motion, a suggestion that Mr. Morrissey recused his office from prosecuting Mr. Kearney due to a conflict created by an investigating journalist who publicly accused the DA's office. I'm not sure that Mr. Morrissey has made a statement explaining why he appointed a special prosecutor, but I'm ready to stand to be corrected, but certainly this is the explanation that might sound most favorable to the defendant, but what does it have to do with disqualifying me? He then talks about accusations against Lieutenant Tully and former Trooper Proctor and Sergeant Uri Buchanan. What does that have to do with disqualifying me? He talks about actions by Sergeant Buchanan taken after he left the Norfolk District Attorney's Office in support of a legal civil dispute between Ms. Reed and the alleged victims in this case. That has nothing to do with whether I should be disqualified. We've talked about my voluntary withdrawal from the indictments concerning Ms. Kearney. And if Your Honor would take a look at page 6, where we have bullet points. All right? The first bullet point is absolutely relevant, and that's what we've talked about, that I'm being sued for intentional misconduct by Ms. Kearney. And we hear that Lieutenant Tully is being sued by Ms. Kearney. So what? The Detective Tully has been sued by Karen Reed. What's that got to do with the price of beans, as they say? That there were disciplinary proceedings against Lieutenant Tully.
That might be relevant on cross, you'd agree?
Oh, yeah, it might have some relevance on cross, but what has it to do with disqualifying me, Your Honor? They weren't disciplinary proceedings
Fair point.
against me. We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed, but what has it to do to disqualifying me in this case? We hear that Buchanan was disciplined. That Proctor has been sued by Ms. Reed. That Proctor has had disparaging text about Ms. Reed. There are two things that the upcoming case should not be about, Your Honor, and I'm sorry I'm losing my voice here, excuse me. One, it should not be a trial of the case that has been null pros concerning Ms. Kearney. And two, it should not be a retrial of the Karen Reed case. None of this stuff is relevant. Kearney's testimony will undermine the credibility of Detective Lieutenant Tully and Ms. McCabe, which will subject her to cross-examination by Mr. Cosgrove. So let's look specifically, if I can skip ahead in the memorandum. The argument that's been made a little later on in the memorandum, in which Your Honor has heard again today. And I'm looking now at page 16, Your Honor, the first full paragraph. Ms. Kearney will testify that Detective Lieutenant Tully intentionally mishandled her cell phone by tampering with and or deleting its contents. Detective Lieutenant Tully will deny this. Mr. Cosgrove has accepted Detective Lieutenant Tully's explanation without any further investigation. Well, I don't know how the defense knows that I've accepted Detective Lieutenant Tully's explanation without any further investigation. But let's put this on a timeline. It has been the contention of the defense from the start of the case that certain items were missing from the download of Ms. Kearney's cell phone. And their explanation is that must be because Detective Lieutenant Tully deleted it. I responded to that. Ms. Kearney is a latecomer to this discussion. She is only now, in the form of either public statements or representations by the defense as to her new position, suggested that this is because Detective Lieutenant Tully tampered with it or deleted its contents. By the way, I don't know how she would know that because she was not there during the download of her cell phone and the transfer of it. But at any rate, my response as to what happened to the cell phone occurred before Ms. Gattani made any of these statements whatsoever. I don't know how it can be that I have been siding with Detective Lieutenant Tully over Ms. Gattani. I haven't seen an affidavit from Ms. Gattani. I haven't seen anything from Ms. Gattani other than hearsay, which is just a representation. And certainly, but let's assume that I do, as they put it, side with Detective Lieutenants Tully in cross-examining Ms. Gattani and in the closing argument. What does that have to do with defending my position in the Middlesex case, and how is it relevant, and how would it even be introduced? I have no idea. Let me back up and make a couple of other points. I want to turn to the legal argument, say a little bit about the law, and I suspect Your Honor has probably already looked at the two cases cited by Mr. Betterow, Commonwealth versus Dunlap, and the other case is named US v. Health, which involves a complicated civil action involving the Church of Scientology and others. The first thing to say about these cases is they're Pennsylvania cases, not Massachusetts cases. So at best, I would say they are persuasive authority, not binding authority.
I don't think Ms. Betterow contests otherwise.
No,
contends otherwise.
Right. The second thing I would say is that they are both opinions in which the court declined to rule for the defense on the conflict of interest argument. In the first case, Dunlap, the decision of the Superior Court judge was affirmed by an equally divided court. The dissenting justices characterized the other side as the majority, but the opinion itself says that the appellate court was equally divided. So I'm not sure if it's even good as dicta. It seems to me it has no precedential value at all, but if it does have precedential value, it was a ruling in favor of the Commonwealth. And what were the facts? In a sentence from the dissent, that is, those who believe there was a conflict of interest, the district attorney who prosecuted this case also represented the victim in a civil suit arising out of the same transaction. That is a mile away. That is a stadium away. That is a continent away from the facts in this case. I am certainly not representing Ms. Gattani in a civil suit arising out of the events that bring the defendant into court. Now let's take a look at US v. Health, or Health, I guess it is, which is the federal case. That does have some interesting parallels to this case. According to the decision, and I apologize for not having the pin sites, but I think Your Honor will readily find them. The defendants contended on appeal that they were denied due process because two prosecutors were defendants in a civil action filed by the Church of Scientology 10 days after the events that went down in this particular case. And they alleged, and the events that went down were a search of the Scientology's office in Los Angeles, and they alleged that the raids were conducted in bad faith with the intention of violating Scientology's constitutional rights. We can look back at the memos filed by the defense, and the contention they're trying to make, well, one of them is that this is a bad faith prosecution. So that applies here. What is different here is the civil suit apparently precedes the raid that the prosecutors make in the defense office in the Church of Scientology. Here, there's nothing like that. The events that the defendant was charged with in this case occur before any involvement by Ms. Kearney, before any involvement, by that matter, with me. And those issues are pretty well set and have consistently been followed through. Now, here's another similarity between Hite and the current case. I'll just read a sentence or two. The government contends that prosecutors cannot be disqualified when sued by a defendant because defendants could then remove whichever prosecutor they please simply by suing him. Now, of course, the defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential conflict. I have not gone so far as to represent to the court that I cannot be disqualified when sued by a defendant or by Ms. Kearney. I think in fairness, the court can look at it. But the federal court, the argument was that any suit complaining of an action taken in the prosecutor's quasi-judicial capacity would be frivolous and non-disqualifying because he enjoys absolute immunity as a prosecutor. Cite to a U.S. Supreme Court case. I believe as Your Honor reads through, we'll find that the court in Hite pretty much bought that argument. And they go on to say that appellants have made no credible claim of actual prejudice based on the prosecutor's alleged pecuniary or personal interest in the outcome of this prosecution. I certainly have no pecuniary interest in the outcome of this prosecution. I have no personal interest in the outcome of this prosecution. And nothing in this prosecution is going to affect anything that's going on in Middlesex.
It's not Middlesex.
Worcester Superior Court, Your Honor.
Understood. Any further? From Mr. Cosgrove.
Sorry. No, I'll stop at that point, Your Honor.
Mr. Betterow.
Yes, thank you, Your Honor.
We might as well start from the back with U.S. v. Health, Your Honor, which is 668 Federal 2nd, 1238, the D.C. Circuit, 1981. Mr. Cosgrove has buried the lead about Health and about Dunlop. Those were appellate arguments post-conviction. Now, that is a huge distinction about a timely motion in advance, raising issues which could lead to a conflict. We all know that raising a conflict on appeal when you could have raised it before is looked at in an entirely different way. And the relevant language from Health that I would direct the court to is on page 1276, which states, given the need to promote the appearance of justice, a trial court on timely motion to wit, like here, should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. That's here.
So the key words there
alleging bad faith. I'm not sure that there's an allegation in those other complaints of bad faith. There's an allegation he violated the statute. I'm not sure where it talks about bad faith.
Sued him for intentional infliction of emotional distress,
Negligent infliction. There's a difference.
She sued for intentional.
I read negligent, but I'll go on.
Respectfully, Your Honor, there are deliberate allegations of intentional misconduct in the complaint, but that's, the court can obviously go back and one of us.
We took judicial notice.
Exactly.
So
one of us is right.
I read this morning as negligent, but that's, I could.
Dunlop is the same situation, Your Honor. It's post-conviction. The other issue, and I want to go back to the beginning that Mr. Cosgrove started with, he illustrates the whole problem here. He's defending himself, and I have no opinion on the merits of Ms. Gaetani's claim, okay? As a lawyer, I sympathize. But he started by telling you that this case is going to get dismissed, and all I did was turn over this. He is illustrating front and center his personal interest that Gaetani is accusing him of things he didn't do. And the conflict, the personal interest, isn't the outcome.
He's not accusing him of things he didn't do. He acknowledges doing.
But he's justifying it and saying she's trying to do this, she's not credible. The point is this: the personal interest for Mr. Cosgrove is not whether he was wrongfully sued or whether it has any merit. His good name has been attacked. And like anyone else, he has an absolute right and a personal interest in defending himself. And again, the proper forum to do that is not while prosecuting a case in which his accuser is a witness, his co-defendant is a witness, and Ms. Gaetani is going to probably impeach, assuming she's allowed to, their star witness, Ms. McCabe. When someone's integrity is attacked, they have a personal interest, especially someone as credentialed and respected as Mr. Cosgrove. We all understand that as lawyers and judges, but that doesn't mean you get to prosecute the case. That's for you to decide, obviously. And we're talking about an appearance. This looks terrible, which leads to my next point. Mr. Cosgrove went through all of these allegations in our papers about, Proctor had this, Tully's been sanctioned, Buchanan, it's literally aligned with Jennifer McCabe, which we wrote about, supporting her. Buchanan was a witness in this case too, and part of the investigation.
But not anymore.
No, but the point is this: he is looking at this in a vacuum. The public must have confidence. Part of the analysis of a conflict of interest is the first sentence of the brief that he just cited from, is that the public must have confidence in the criminal justice system. And this latest conflict is a pile on conflict after conflict after conflict in this case. And if the cherry on the sundae...
But let's just, let me slow you down, because we're conflating two different issues. I'll agree with you. There's all sorts of issues that have developed over the course of these interrelated prosecutions. Mr. Cosgrove's role, though, is a latecomer and really had nothing to do with any of these other issues. So I can't sit and say I impute all of those other things to Mr. Cosgrove. And therefore, if we look at that mass of problems that have developed, he's out. Because the same logic would say the next person who sits in that seat, the same argument would apply.
Let me be very clear. I'm not accusing...
I didn't take it that you were.
Fair enough.
But my point is, all of those things are conditions which are already present in this prosecution.
They are.
So really the only thing that I'm dealing with is this one issue, because the rest of those things he had nothing to do with.
Well, one of them, he had this other conflict which he voluntarily sought.
But that came out of the same exact issue.
Yes. Well, that's our point. We think it's the same conflict.
I agree with you. But what I'm trying to, the point I'm trying to draw and the distinction is, all of these other problems that arose out of the Reed prosecution, real, imagined, substantial, that's really not for me to decide, right? They're all out there, all right? And they're all going to be there no matter what. So whoever sits in that chair right there is going to have all of those problems.
Difference, I don't mean to cut you off, Your Honor. The difference is that if it's not Mr. Cosgrove, the man who or woman who would be sitting in that chair is not being sued by Ms. Gaetani and co-defendants with DL Public.
That's my point. That's the only thing I have to analyze.
Okay.
That point.
Our point, respectfully, was that given the public's need for confidence in this case, not the Karen Reed case, that's a whole nother conversation for someone else on another day. But this case is filled with conflicts, and I don't think we can all just avert our eyes to and say, but none of that matters, but we're going to have a prosecutor now cross-examine his accuser and then say she's not credible. He also indicated, Your Honor, you know, they're not even calling Ms. Gaetani. I can't fathom how that might happen. You know, they use careful language. They may call her. We're the defense. We don't have to do anything. We can take a nap throughout this trial.
Understood.
And there may be such a terrible joke of a case they present that we stand up and rest. So, of course, why would any credible, serious lawyer commit a year in advance? I'm calling this witness. We're alerting Mr. Cosgrove to what we think is his conflict and the court, and we may very well do that. The last point for this, you know, he said there's no affidavit from Ms. Gaetani, or it's all just hearsay about, you know, tampering with her phone. The best basis for that will be the posting online social media by a third party and long-time known critic of Mr. Kearney of messages which did not appear on an extraction report that we got from Tully of Gaetani's phone, and then we never got anything from Tully's phone. We got screenshots of what he claimed were messages. That's the basis for that. Thank you.
Okay, fair enough. All right, so here's what we'll do. We're going to set another date. Let me talk about this. Mr. Brady, when we selected we penciled in the trial date, I gave you a very long date, longer than I wanted. Your schedule, has it changed? Can we get this thing done earlier? Assuming it's alive?
Judge, it's probably gotten worse.
All right, well, we're not moving the case back. That trial date's not going to go backwards.
Okay.
This is a 2023 case. It's 2026. It's not going backwards. If anything, it's going to move forward. So don't.
I know you'll relate to this, Judge. I have the usual
I
slate
know.
of like fall murder cases.
I get it. I get it. But this one's an old one, and it's set. So I was going to try to move you forward. But if you tell me that can't happen, then that can't happen.
I'm sorry.
All right, but understood. This court is willing to take this case much faster than the current schedule.
Get that, Your Honor. We do have a few other pretrial matters to address. Your Honor mentioned the motion to dismiss. Maybe we should schedule that.
What we're gonna do is this. I'm gonna take this under advisement. We're gonna pick a date right now. And either we do a motion to dismiss that day, or we're on for appearance of new counsel that day. All right, one or the other. We're gonna know. I'll get you a decision beforehand. Now, I am open to the idea that if I accept there's a conflict here, I haven't made that determination yet, but if I accept there's a conflict, I'm open to the idea that it's resolvable by having someone else step in and cross-examine her. I think that solves all of the issues. So that might be the easy way here, so everybody can get this thing moving and have this trial, which all parties seem to desire.
So just on that point, I appreciate you kind of reflecting your thought process. But, you know, even if counsel stays on the case but doesn't actually do the questioning, it still remains that there's a conflicted counsel on the case, and the jury ought to know
you and I both know
that interest.
Mr. Bradley, you and I both know this happens with some frequency, and we work our way around. All right, the jury's concentration in this case is on the events of the case. Now, Ms. McCabe's credibility, I expect to be a robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But Mr. Cosgrove raises a reasonably good point that, you know, there's been some recent case law talking about, you know, the police can't create their own exigency. And to some extent, the defendant has created his own exigency here, because in fact, the plaintiff in that case is suing because the contents of her phone were put on the internet. The defendant did that. So there is some, you know, you got to be fair to both sides here and say this is something which only happened because of steps taken by the defendant.
Well, Judge, I don't want our lack of response to that to be perceived as a acknowledgement. I don't want to address that.
I'm basing that simply on what I read in her complaint, not on anything that's been represented to me today.
Right, exactly. And so, just a couple rewinds here, judges, that the government themselves, in Lieutenant Tully's own affidavit at the time of this, back in December of 23, swore in the affidavit that Ms. Gattani was a witness in the matter. And so I don't think the government can do a 180 and say, oh, she's not really a witness.
Oh, she's a witness, but she was a witness at that point. They were trying to indict your client for some sort of conspiracy charge, which failed. Right. All right, and the grand jury didn't
live and under investigation.
Well, that's another matter. I've told you I have no authority to affect that. What I do know is that was no build.
No build.
Even worse. Okay, that was no build. So I can't imagine a circumstance where I would allow evidence in about a no build issue. I remain to be persuaded on that. But,
so what? And just to go to the lowest hanging fruit on why Ms. Gattani would be a witness, there's all sorts of screenshots and text messages, and we need these things authenticated before we use them. I'm not necessarily saying that can't happen. There's all sorts of reasons.
I get that, but
no one's trying to trigger a recusal. There's a lot of good reasons why she's involved in this. The government's own affidavit.
I'm not discrediting what you're saying. What I'm saying to you is, I think there's a way around this. And I don't know that a closing argument is going to change that, because the closing argument is based on what's heard at the trial, and I'd add, in this court's view, and in the proper practice, would be confined strictly to the evidence that's presented before the court. So, no, it's not going to.
I appreciate your reflections, Judge. If I could just have one moment.
Yeah.
Well, I think the judge has telegraphed.
Thank you very much. That's all we have. And just
let's pick a date.
Okay. Are you late February, March? Okay, early March. What would you like, Your Honor?
Let's go later in March.
All right, March 27th.
Is that a Friday? Fridays are generally best.
I can do that. It is a Friday.
Do it on a Friday.
Thank you.
I don't know if we'll be in this room. I'll have to consult with the occupant who has generously lent me this room today.
I want to say one other thing, if I could,
Sure.
Your Honor. I am concerned that the protective orders that have been issued by the court have been the subject of violations. I'm not prepared to address it today, but I want to put the defense and the court on notice that I do think there's a basis for that argument, and I will plan on raising it at the next hearing.
Well, raise it first with the other side, so that they're aware of your concerns.
I will, of course.
All right. If it's not resolvable, then the court will step in. Nobody benefits by undermining the protective orders. Look, again, the way this court looks at this is that this is an important First Amendment issue, which should be decided by a jury of the defendant's peers to decide the mores of our society, whether or not this is journalistic activity or it's not journalistic activity. Let's try to focus on that, folks.
I absolutely agree with that, Your Honor.
Okay. All right. Anything else we can do today?
No, sir.
March 27th, the purpose of that hearing to be determined, but it's going to be one of those two things.
Thank you.
Okay.
Thank you very much, Your Honor.
All right.
Your Honor.
All right, both matters continued to March 27th, time and session.
Court, all right, please. Get into the courtroom at this time, please. Thank you.
Free Turtle Boy, free Turtle Boy, free Turtle Boy.
Okay. Well, you have just heard. All right. Let me see. I thought I stopped the stream of. I thought I stopped the stream. I did stop. I thank Broken Baker for. He actually took the Zoom stream, which you weren't supposed to take unless you were authenticated media, but he's out of the country and he allowed us to all do it, so we had to shine a light on what just happened in that courthouse and courtroom. And I will say again that all of you know that Michael Bryant is there. He was in the courtroom. He's going to give us his feeling about what happened. He's probably not going to do it by standing outside because apparently it is so cold up there you cannot stand outside the courtroom. All right. This is just, quite frankly, one thing the court said, and let me type it up. Court said, jury must decide if journalism, and I'm going to put this in because you know how I type. I'm not great as a typist or keyboarder. If journalism is what Aiden was practicing, and that is after the court recognized, earlier in the argument, so you're giving me my thoughts, earlier in the argument, Aiden is a journalist. A new type of journalist, which is what we all are. New type. Okay, so let me make sure after the court, because I don't want to misquote the court. There's a new type of journalist. New type. All right. So I don't think that's a jury issue. I think if you're practicing journalism, it's a matter of law. Period. It's a First Amendment matter of law. And the court did say that he was absolutely sure that if it's First Amendment, it's a very important issue if it is First Amendment. But how do you let a jury decide if it's a First Amendment issue or not? I mean, that's exactly what judges are getting the big money for. Now, this is the first time we really heard this judge. I was very impressed with him initially in the first Zoom hearing, but he was very staccato today. Okay. Yep. And interrupting people. And he actually interrupted both sides with putting out what he thinks. He basically thinks that if he finds a conflict, and he may find the conflict because of the idea that it could be a conflict or appearance of conflict, he's just going to appoint one of the special prosecutors to step in to cross-examine the witness, Lindsay Gaetani, if she is indeed called to the stand and testified in Aiden's trial. So what he's saying is that may never happen. And if it does happen, I can resolve it when we get to that point by having somebody who it doesn't have the appearance of conflict or a conflict, if I found one, cross-examine her. But Mark Betterow makes the point that, but the person with the conflict is sitting at counsel table. This would never fly in a law firm. I mean, it just wouldn't fly. I mean, what they're trying to do is, it seems to me, is go through all these machinations to make sure that Cosgrove stays in as a prosecutor, which kind of tells me that maybe they don't have anyone willing to take these cases at all. Because remember what Cosgrove said last time he appeared before this judge, that if the judge boots him from this case, he's got to boot him from all, he's going to resign on the other cases. He's just not going to do them. It doesn't make any sense for him to do them. But here, Cosgrove, the judge then said something that I thought was questionable. He blamed Aiden for the fact that there may be a conflict with Cosgrove because of Lindsay Gaetani. How could Aiden be responsible for a conflict of interest? Lindsay Gaetani has sued Cosgrove, period. She's sued Cosgrove, period. End of discussion, you know? And then at the last salvo, we get not from the judge, but we get from Cosgrove when he feels he's kind of now a winner, is that he says, I want to bring to the court's attention that I think that there's been violations of protective orders. And this is always, what prosecutors do, violation of protective orders. Therefore, we may have to have a contempt proceeding. People try to do that all the time. All right. And the judge then said, well, if you think that, why don't you go to the defense first? Why don't you go there? And then if you can't resolve whatever it is, you come back to me. But there's Cosgrove again, trying to put the nail in. So there we go. that's kind of a sum up of what happened. I thank Broken Baker. It's amazing. Michael Bryant was there early this morning. Okay, was there yesterday. He went and got the approval. But then you get there and to set up, and there's no Wi-Fi. There's no Wi-Fi, whether it's in that courtroom. It's in the courthouse, apparently. When I was there for Hernandez, we had our own little Verizon hotspot because for security purposes, we don't want somebody being on the same Wi-Fi we were on. So we had our own little internal Wi-Fi of all the counsel sitting right there at counsel table. But apparently, you couldn't even, at that courtroom where it wasn't an 8, you couldn't even get cellular service that could support the stream because you need a lot of megabytes. So we couldn't get the cellular service, and the hotspots didn't work either because the hotspots couldn't get the cellular service either. Okay, so you couldn't hook onto a hotspot that would give it to your phone to get the cellular service, I guess, unless it was your specific, maybe Verizon hotspot that you have connected to your computer. But whatever it was, that and I'm not sure what courtroom they were in. I'll have to go back and see what courtroom we were in Aaron Hernandez's case. So that is why I thank Broken Baker, who got on the Zoom, and he's in a different country. He got on the Zoom, and he said anyone who wanted to share could share it, so we shared. And I really thank him. I ask you to go, obviously, all follow him. But I did announce Michael Bryant is there. He is posting pictures, and he is posting pictures, right? Outside in the courtroom because they weren't allowed into the court till about, the reason why I was late, about 8:45 or 8:40 or so until Tim Bradle got there. Tim Bradle was late getting there and all. So, that's why that was late to begin with. And this should be an easy thing. It should be all outlets that are journalists have activity to the Zoom. And there shouldn't be a question about if you rebroadcast unless you have been approved. And we're approved journalists in Massachusetts, and we were approved for broadcasting this as a streaming service. So I didn't expect that we'd have to go roundabout and broadcast it for somebody else who was taking it on Zoom. Other people cut off their Zooms because they weren't approved. So I thank Broken Baker again. I can't thank him enough and all. So the judge said, yes, I heard the judge say. Now the judge, the fact that you don't want the spotlight on what is one of the most important cases for a lot of people arising out of not only the Karen Reed trial, because if it wasn't for Aiden Kearney, Karen Reed acquittal would not have happened. He's taken down the whole state police. And when you do that, you make enemies and they're after him. And people then feel, since Massachusetts is going after him, we can go after him in this state, we can go after him in that state, we can go after him here, we can go after him here and all. And the question comes back down to the issue of what is journalism. We see this morning, Don Lemon gets arrested for practicing journalism. We saw in Las Vegas last week, a judge had entered an order that said you had to have approval to be in the courtroom if you were a journalist, and I had pre-approval of what you were going to write. And Mark Randazzo, who is Michael Bryant's lawyer, got immediately involved in that, and that was immediately reversed by the Nevada Supreme Court because judges are, and now they found out, well, if you just don't give access, if you don't have Wi-Fi, and all, no one can see. Now, Channel 7 was there was it Channel 5 or Channel 7? Channel 7 was there from Boston, but when I was on their website, they weren't streaming it. So obviously they have captured the whole thing. They'll probably put it on their website, and then we'll be able to use it from them. Okay. Yes, there is the link last night where we discussed LG. We put her as lawsuit against Cosgrove. And indeed, the judge wasn't even familiar with the fact that she has sued him for intentional infliction of emotional distress instead, not just negligent infliction of emotional distress. So an intentional infliction of emotional stress, and he had to be corrected and all by Mark Betterow. Now, if I am, here's the problem. Linda loved first. Linda F. loved first. Here's the problem. This is a new kind of journalism we have out here. Legacy media is sort of dead. You didn't even see really a lot of legacy media come to this, right? And even in Karen Reed, when you saw them come, they come for openings, they come for closings, they come for the provocateur witnesses. If Proctor had testified, they would have been there for the second trial on that. So the reason why is all of us who have become journalists, and the judge recognized that Aiden Kearney is a journalist and the new kind of journalism. It is. So I mean, it's just beyond, and beyond. In any event, I think the protection of the First Amendment is most important. Don't make exception because you don't like the politics of somebody. And don't make exception because you don't like the fact that somebody like Aiden may have taken down the Massachusetts State Police. You can't say journalism is protected only if it's one political party or if it's one side. The side that protects the government is protected, or one political party is protected. Journalism is shining an eye, shining a light, opening the door on what is happening. And now YouTube has given us that ability to do this. And that's why we have Justice Served TV. Now, this streaming is probably, I should probably close it down. I do want to talk to, see if Michael Bryant, I know he's probably outside. He's going to be doing interviews. Now, the bailiffs were pretty good. They let him post. Usually you can't take pictures around in the hallways of the courtroom and post them. But Michael got approval first, and that's why X has some of his pictures. He is going to then take and do interviews, try to post them before he leaves Boston. But you know what? We found out the Starlink, when it gets really cold, doesn't work outside. It was so cold, it didn't work. All right. Now, the Starlinks that are attached to your houses work because they have a heater inside. So he couldn't even stream outside from the Starlink. Not that he wanted to, because it was really, really cold. But so stay tuned. I would suggest to you to stay tuned to our YouTube account and our X account. I know Michael's going to be posting little clips. He may not post whole interviews until he gets to a place that he can upload them. But then at 6 p.m. tonight, Justice Served TV will be back on the air, probably without my emotional support dog, Tubi. I found I needed him during those arguments, so I gave you a little look at Tubi, who really wasn't really happy sitting on my lap listening to this. I think he wanted to go have breakfast. But we will be back on the air, Justice Served TV, at 6 o'clock tonight. And as I said, exciting news. We have Aiden Kearney himself, and we will have Mark Bedrow himself. They will join us right at the top of the hour. So spread the word, subscribe, share, like, notify, hype. But don't be late tonight, because normally we run our banter till you all get settled. You know, everyone gets the notification. You have to be on at 6, because that's when they're coming on, 6 o'clock tonight for the first segment of the show. Aiden Kearney and Mark Bedrow, their reactions to Justice Served TV. I will remind you that I do represent Aiden Kearney in the Atlantic City case, along with Darren Gelber. So you have that disclosure for those that may have missed that or do not know it. But again, Mark and Aiden are joining us tonight at 6 p.m. Sheila Duffy will be with us. I hope all of you come back will be with us, but spread that word, okay? Now, I posted it on our X account, which is at Justice Served TV, on X, on Twitter, as sometimes we still call it. I think we say X and then we say post a tweet, but at Justice Served TV, with the headline, Special Prosecutor Cosgrove out, ? What do you all think? We'll talk about it, because the judge did not make a ruling today. Well, see you tonight at 6. I'm Linda Kenny Bodden for Justice Served TV. Thank you for joining me.